Hello, thank you for joining us again this week. It's been quite another week of important decisions in the landscape. I want everyone to share their experiences here. We've had such good feedback and such good, I don't know, people have been listening to it, sharing it, and it's been wonderful. So there's a bit of a slower attendance this week. I'm not sure why. Maybe it's the cold weather or it's Friday afternoon, but I've certainly still got my glass of, well, it's not red, it's rosé. So I really encourage you to get your glass of wine and listen to the cases. Okay, so let's start. I've introduced myself a few times, so I won't keep doing that. I'm going to talk about a couple of the cases that we talked about last week because I think it was a little bit quick. We're having technological problems. We're having more technological problems today still. It seems to be, maybe it's me, maybe I attract them, I'm not sure, but anyway. So we've got a few decisions here. There's a new one that I want to talk about where excessive socialising was what the Justice said in relation to messaging. So we'll get into that in a moment. Let's go over Leonie McCready. Leonie McCready it's 3 weeks ago now, but it was really the first decision. She was earning $375 as her normal salary, and with JobKeeper got $750. I suspect that might have annoyed the Commissioner a little bit because he was quite firm when he ordered. The employer wanted her to take 1 day a week of annual leave to reduce their liability, and there was a huge liability. She had, I think, 10 weeks of annual leave up her sleeve, and I can't remember, quite a bit of long service leave as well. So, as you know, as employers, when you've got all this liability hanging over your head, it's a financial burden and cost on the business. So, as part of her JobKeeper, they wanted her to take 1 day a week of paid annual leave. She refused. She said she had a holiday booked to go overseas and she was saving all her annual leave for that. But it was noted by the Commissioner that the annual leave hadn't actually been, the leave to go overseas hadn't actually ever been approved. So she refused to take it, and the dispute was handed into the Fair Work Commission under their new powers. We all know now, because after last week, that they've got new powers to manage disputes in relation to JobKeeper. So the Commissioner ordered that she was not to continue to refuse the request made by her employer. That is, she was to take the 1 day a week. I think it's a really interesting decision because I think that what's happening at the moment, and I talked about this a little bit last week, is that the government certainly, and obviously the Commission in this instance, is taking a very pro-employer approach to matters. Now, a barrister I was talking to during the week said that was because Morrison, filled the Commission with pro-employer commissioners before the last election. But I also think it's to do with the fact that no one wants to see businesses go under. And so they're trying to do everything they can to support businesses and try and keep them afloat during this time. So let's watch this space for more cases. There are more cases, trickling through. I did mention a few weeks ago when I was talking at another seminar that the caseload of the Fair Work Commission for April this year and April last year was 60% higher this year. So there's a lot of issues going on out there around JobKeeper, employees being stood down, not being stood down. So it's a very complicated space and there's a lot of conflict. Let's look at underpayments. Underpayments is my bugbear. I just hate it because so many shoddy employers, pardon me saying that, underpay vulnerable people, either migrants or, international students or holiday visa holders. So this company really annoyed the Fair Work Ombudsman. As we all know, Fair Work Ombudsman is a body set up under the Fair Work Act with extremely broad powers and high powers, not just broad but deep powers. They can come into your workplace and demand to see your pay records, your employee records, a whole lot of things. So when they received a complaint in this matter, they went and wanted to see all the pay records. And I think what really peeved them was that the payroll officers reverse engineered the records. They made up records during the investigation. So the company, got a big fine. the actual individuals who did the re-engineering were fined a total of $121,000 because under this legislation, the courts can actually go after individuals as well as the company. They are what's called vicariously liable. So if they actually act inappropriately and breach the law, then they're not protected by the company. So this was, in the end, over $800,000 worth of fines and penalties in this case. And it was the largest penalty ever ordered or ever won by the Fair Work Ombudsman. So, I mean, I think the lesson, we've seen it with 7-Eleven, we've seen it with all these companies, it's not worth underpaying your staff because what will happen is you'll get caught and you'll get fined. When in doubt, call the Fair Work Ombudsman and check the award. Call me and check the award and pay your staff appropriately. Piece it up by the looks of it. This is a very important decision and it's causing, I suppose, lots of shockwaves through the employer sort of circles. But I suppose I've always been opposed to people using casuals like pseudo-permanent employees. If you want someone to work consistent hours every week, then put them on permanently. Don't have them as a casual to try and avoid entitlements that you might owe them. There was a huge case last year. Oh, the name's just got out of my head. Anyway, this is following on from that. This is Robert Rosato, he was a coal mining worker. He was engaged as a casual through WorkPack, an employment agency, on 6 consecutive employment contracts over almost 4 years. Now, on any view, that's a permanent job. He was paid as a casual, so he had the 25% component that made it that he wasn't entitled to annual leave, sick leave, etc. He challenged it and won. So it was held that although WorkPack's offer of casual employment contract had the status of casual in the contract with no annual leave, that Mr. Rosato's regular, predictable working arrangement meant that he was an employee, i.e. a permanent employee, entitled to the benefits under Section 86 of the Fair Work Act. The Federal Court ruled that Rosato was in fact a permanent employee entitled to paid annual personal, carers and compassionate leave, plus payment for public holidays during the Christmas shutdown. Morrison came out immediately and said he was going to change the legislation. And there's been a lot of commentary this week about this case. So it has a lot of repercussions. People can then, it looks like with this decision, people are able, who have been on long-term casual contracts, can retrospectively claim entitlements, which could run into thousands, depending on the size of your enterprise, hundreds of thousands of dollars. So my advice or my view, it's not legal advice, my personal advice is if you have a worker who you want to work regular hours each week, put them on a permanent contract. If you're a small business, you can still dismiss them in the first 12 months. As that's their probation period, really, under the legislation, for want of a better word. But you pay them less and you don't have the risks of this sort of thing coming back to bite you years later. So if you're a casual, you call up on a no notice, I need help today sort of basis, that's a casual. That's a true casual. But someone who's got 6 consecutive employment contracts over 4 years, that's not a casual. And that's what the court held as well. This is an interesting case, Dring versus Telstra Corporation. This just happened this week. A woman she slipped and fell after a night of champagne, wine and cocktails on a work trip. And she wanted to claim compensation for that. She injured herself. It's an interesting case, and those of you who are old enough will remember the case of the woman who had sex in the hotel room and the light fitting fell on her. I'll come up to that. I've got a slide on that in a moment. So she didn't actually win her case. It was held that although Miss Dring was expected to attend a work conference in the morning, the injury, even though it was on a work trip, lacked a connection with her employment. That's really interesting because in the following case, this one went all the way to the High Court before that decision was made. That meant it went to the federal court, then I think it had an appeal to the full bench of the federal court. This is the woman on a business trip with a male colleague, and they had sex in a hotel room. The light fitting fell on her and caused facial injuries. She, I think the first instance, was awarded nearly $600,000 in workers' compensation through Comcare. She won at the federal court. She won at the full bench of the federal court, and it went to the High Court. And in the end, they said no. And look, common sense says it's no, but it's interesting that this decision, in the first instance, said it lacked a connection with her employment, which you would hope that having sex in the hotel room with a male colleague lacked a connection to employment, which is what the High Court ultimately found. So I like the title that one of the articles I read was, hotel sex is not all of a day's work, ultimately. As I've said, I think this space is very complicated. It's getting more and more complicated. I love helping small businesses, and all businesses really work through all their employment law issues. You can see on my website that I now offer employers some sort of subscription option where they can contact me and just bounce ideas and talk to me about issues they've got with their employees at work. So I also recommend that when in doubt, just get advice, because the cost of getting advice early is going to be much cheaper than having to defend an action in court. Thanks for your attention. Please share the word, share the news about Rewine with Rosa. I'm looking now at hosting it at a wine bar going forward, and I'll showcase a wine of the week each week. And if you need any help anytime, always feel free to contact me. Have a great weekend. Thanks for tuning in, and I'll see you next week. Cheers.